In the First Amendment to the Constitution, Congress is prohibited from establishing a religion at the federal level. Here in America, there would be no denomination that would lord it over all the other denominations. In 1947, the Supreme Court took an obscure quote from an obscure letter by Thomas Jefferson, who wasn't even there when they wrote the First Amendment, and said that the no establishment of religion clause means, quote, a wall of separation between church and state, end quote. In 1985, before he was elevated to become Chief Justice of the Supreme Court, Associate Justice William Rehnquist wrote a dissent in a school prayer-related case. He said in that dissent, quote, the wall of separation between church and state is a metaphor based on bad history, a metaphor which has proved useless as a guide to judging. It should be frankly and explicitly abandoned, end quote. Here are some observations on Rehnquist's dissent from Judge Darrell White, the founder and president of Retired Judges in America.
William Rehnquist does the world, but certainly America, a favor in his dissent, his lengthy dissent, in a 1985 case called Wallace versus Jaffrey, in which the issue was whether or not the state of Alabama would be able to maintain a statute that called for a moment of prayer in addition to the existent moment of silence. And sadly, a majority of the court said that that was a violation of separation of church and state. William Rehnquist, on the other hand, wrote that it is impossible to build sound constitutional doctrine upon a mistaken understanding of constitutional history. And he goes on to give a history lesson that speaks of the mistaken understanding that Hugo Black, a justice from Alabama, had placed on the First Amendment's Establishment Clause in a case called Everson versus the Board of Education of Ewing Township, New Jersey. And in the irony of ironies, Professor Daniel Driesbach writes in a book called Thomas Jefferson and the Separation of Church and State that Hugo Black's biographer himself wrote that the justice, meaning Black, acknowledged that he did not even peruse the history surrounding the First Amendment until after the Everson decision had been rendered in 1947. So we have been on a wrong path for a long time now.
Court observers say that some of the damage done by the misunderstanding of church-state relations has been at least partially contained through some of the recent church-state decisions, and that has the left in an uproar. But the Constitution is an important document. It is theoretically the law of the land, and it should not be abused by anybody, including justices of the Supreme Court, to make it say whatever they want it to say. If somebody feels the Constitution needs revision, there's a process for that. It's called the amendment process, which is not easy to do, but that's by design, so that judges couldn't just fritter away our rights by undermining the Constitution by judicial fiat. For Providence Forum, I'm Jerry Newcomb.